Yes, Your Honour.
Okay. All right. Well, I'll call the matter for hearing in the matter of RM against the Crown. Could I have the appearances, please? Team K, do you want to announce your appearances?
May it please the court. My name is Tasnim Ahsan, referred to as Ahsan, spelled A-H-S-A-N, and I appear with my learned junior counsel, Alisha Mathias, referred to as Mathias.
Sorry. My iPhone just fell off. That was a good start to the day. Can you see me? No, I've lost you all. Get another thing.
Probably still getting themselves.
That was spectacular. Have you got me again? Sorry.
Yes.
That was entirely my fault. My iPad just fell off its...
No worries at all.
All right, let's start again. Go.
May it please the court. My name is Tasnim Ahsan, referred to as Ahsan, A-H-S-A-N, and I appear with my learned junior counsel, Alisha Mathias, referred to as Mathias, spelled M-A-T-H-I-A-S, and we appear for RM, the appellant, in this matter. I will deal with ground 2 concerning the admissibility of Dr. Lung's evidence, and my junior counsel will deal with ground 1 concerning the presumption of dollar incapax.
Sit! No, sit!
Someone's not muted, but I'll persist. I will speak for 20 minutes. My junior counsel will speak for 19, and I reserve 1 minute for rebuttal. May it please the court.
Thank you. And could we have the appearances for the respondent, please?
May it please the court. My name is Miss Jones, spelled J-O-N-E-S, initial N, and I am joined by my learned junior, Miss Donovan, spelled E-O-N-O-V-A-N, initial O. I will be speaking for 19 minutes, Miss Donovan for a further 19 minutes, and we reserve 2 minutes for Sir rebuttal.
Thank you, Ms. Jones. Thank you, Ms. Jones. Yes, Senior Counsel for the Appellant, if you could begin, please.
May it please the court. Ahsan for the appellant. The key concern in this case is the operation of the white coat effect. This issue arises when experts, like Dr. Lung, opine on matters outside the scope of their specialised knowledge, and then juries take such opinions to have a higher authoritative value than they are warranted. Accordingly, this court should closely consider if Dr. Lung's evidence meets the two statutory requirements that we will discuss today. We note that in our written submissions, we followed the procedural steps to admissibility. However, today, we will lead with our primary submission concerning Dr. Lung's evidence, which is that his opinions were not wholly or substantially based on his specialised knowledge as required by like terms in section 79 and section 108C. Our secondary submission is that Dr. Lung's evidence cannot be relevant under section 55 of the Evidence Act, or alternatively, it cannot substantially affect the assessment of BH's credibility as required by section 108C. If the court rules in our favour for even one of these submissions, Dr. Lung's evidence is inadmissible. Also finds that Dr. Lung's erroneously admitted evidence influenced the jury's guilty finding at trial, prima facie, the appellant has a right to a new trial, as stated in Clark and Ryan heard in the High Court. Turning to the first issue, namely that for Dr. Lung's evidence to be admissible as expert opinion evidence under Section 79, he must first have specialised knowledge derived from training, study, or experience, and that his opinion is wholly or substantially based on that specialised knowledge. We accept that Dr. Lung has some specialised knowledge based on training, study, or experience. What is in contention is the scope of his specialised knowledge, and therefore whether the evidence adduced by Dr. Lung at trial was wholly and substantially based on this specialised knowledge. The first issue, the scope of Dr. Lung's specialised knowledge encompasses only the impacts and sequelae of child sexual abuse, which can be found at paragraph 2.9 of the facts. We take issue with our learned friends.
Ms. Ahsan, if I could interject at this point. So just to get to the crux of your point, why do you say that Dr. Lung's specialist knowledge is inadequate?
Your Honour, we are not submitting that Dr. Lung has inadequate specialised knowledge. We accept that he has specialised knowledge on impacts and sequelae of child sexual abuse, but our submission is that the scope of this specialised knowledge does not capture the type and the nature of the evidence that he gave on behavioural responses of child sexual abuse victims.
Thank you for that clarification.
We take issue with our learned friend's broad construction of Dr. Lung's specialised knowledge. As they've mentioned, his academic qualifications in criminology and psychology. However, these are very broad areas of study. And just because someone has an academic qualification in this area does not mean they have specialised knowledge on all the various topics that fall within it. For example, in Wood against the Queen, heard in the New South Wales Court of Appeal, the expert had academic qualifications in physics, but this did not mean he had specialised knowledge on all topics. Instead, what was found was that he had expertise in plasma physics, but not in biomechanical physics. There is nothing to indicate that during academic studies, he dealt with the particular topics concerning behavioural responses of child sexual abuse victims, grooming, or bracing circumstances. We also take issue with our learned friends relying on the skeletal statement in clarifications C.1 in the first paragraph, that Dr. Lung has publications related to behavioural responses. This statement does not indicate how many publications, or plainly, how much research experience Dr. Lung actually has on the particular topic of behavioural responses. Therefore, to draw the conclusion that now he is an expert on this, an expert with specialised knowledge on the particular topic of behavioural responses is erroneous.
Ms. Ahsan, could I ask, what would that expertise look like? What would the indicators of that expertise require?
Your Honour, we submit that for the nature of the evidence that Dr. Long provided, which was about behavioural responses, he needed to have some clinical experience.
And could you point us to the relevant case law that establishes that requirement?
Your Honour, the case law in MA against the Queen considered an expert who had clinical experience as well as research experience. And on that case, they found that because of the expert's clinical experience, this informed their understanding of the academic research papers that they relied on when giving evidence. Therefore, the type of evidence in MA against the Queen, which was also specifically behavioural response, specifically delay, acquiescence, and interaction with the perpetrator, the same as we've got in this case today, we would submit that an expert cannot rely solely on research experience to base their opinions on behavioural response, but at least needs clinical experience to supplement their understanding of the research papers.
So if I understand your submission correctly, you're suggesting that a clinician with no research experience would have the requisite expertise, but a researcher without the clinical experience would not.
Your Honour, for the nature of the opinion given in relation to behavioural responses, yes, because we would submit that clinicians are unique because of their interaction with patients, and when they speak to patients, they are directly dealing with how and why a victim responds in a particular way. Therefore, a clinician without the research experience would be permissible to give this type of behavioural evidence.
Thank you, Ms. Ahsan.
Before turning to the second issue, if I may take your honours to paragraph 2.8 of the facts. Dr. Lung had adduced 4 key pieces of evidence. At dot point 1, a child's acquiescence to sexual abuse. Dot point 2, their delay in disclosure. Dot point 3, the continued interaction with perpetrators. And dot point 4, the role of grooming in child sexual abuse and the commonality of it occurring in breaking circumstances. There's a meaningful difference to be made between points 1, 2, and 3. It's about the behavioural responses of victims compared to dot point 4, which is about the pattern of behaviour of perpetrators. Now, bearing in mind Dr. Lung's limited scope of specialised knowledge, we submit for 2 reasons that Dr. Lung's evidence on behavioural responses, namely acquiescence, delay, and continued interaction, falls outside the scope of his specialised knowledge, which pertains specifically to impacts and sequelae. Third,
Ms. Ahsan, what do you say to the assertion that, at least in relation to the role of grooming, that understanding the role of grooming is fundamental to understanding the dynamics of child sexual abuse, and therefore inherently relates to understanding the behavioural responses of victims?
Your Honour, could you repeat the end of your question, sorry?
Yes, I'm asking about that distinction that you've made between the first 3 dot points and the last 2 dot points. The first 3 dot points as pertaining to behavioural responses, and the last two not doing so. And I'm asking, I'm questioning that distinction in relation to at least the fourth dot point, which is that the role of grooming arguably is not distinguishable in the way that you're suggesting, because the role of grooming fundamentally is about the dynamics of the abuse, and understanding the dynamics of the abuse inherently relates to understanding the behavioural responses of victims.
Your Honour, the distinction that we make with dot points 1 to 3 is that it goes to the credibility of the complainant. It speaks to the behavioural response a victim has to the behaviour of a perpetrator. Whereas with dot point 4, the role of grooming, which is conduct by the perpetrator, and the commonality of the perpetrator doing these actions in brazen circumstances, goes to the conduct of the perpetrator rather than impacting the credibility of the complainant. These two types of evidence had different purposes when adduced at trial. The first 3 dot points were adduced to explain to the jury the counterintuitive behavioural response a victim may have to abuse. Whereas the fourth dot point and the type of evidence in the fourth dot point was not considered in MA against the Queen, and we would submit does not fall under the scope of behavioural responses of a victim, and therefore distinguishing of evidence with different purposes.
Thank you for that clarification, Ms. Ahsan.
While you've been interrupted, could I just ask, was there really any evidence in the complainant's account that you would characterise as grooming?
No, Your Honour. And there was no evidence brought by the Crown at trial that indicated there to be grooming or offences occurring at brazen circumstances.
Thank you.
The reason why impacts and sequelae are different to lungs evidence on behavioural responses comes down to 2 main issues. And that's first, that understanding behavioural responses of victims requires an understanding on the behavioural psychology that underpins how and why a victim responds to assault in a certain way. Whereas opinions on the impacts and sequelae consider the effects abuse has on a victim and not necessarily their response to the abuse. Second, behavioural response evidence focuses on a victim's temporaneous reaction to the perpetrator, thereby requiring a close understanding of those relationships and dynamics. Whereas Dr. Lung's knowledge on impacts and sequelae focuses on the consequences suffered by the victim, does not necessarily consider the victim's relationship with the perpetrator. Therefore, these topics of behavioural response is general understanding of impacts and sequelae. Now, turning to Dr. Lung's 4th piece of evidence on grooming and brazen circumstances. This evidence particularly falls outside the scope of his specialised knowledge because it was specifically about the pattern of behaviour of perpetrators before the abuse. Whereas Dr. Lung's specialised knowledge is on the impacts on victims after the abuse. We acknowledge that Dr. Lung has research on causes of crime. However, this is a very broad area of study, and once again, there is nothing to indicate that he has specialised knowledge on grooming and child sexual offences occurring in brazen circumstances. For example, his research on causes of crime may have focused on homicide or domestic violence or something else, and not even touch upon the issues and matters of child sexual abuse. These are important distinctions to make between the actual scope of Dr. Lung's specialised knowledge and the matters that he did opine on. And that was demonstrated by Justice Baldwin's concern in HB against the Queen, that allowing experts to include and slip in certain opinions which actually fall outside the scope of their specialised knowledge means juries may perceive such opinions as more authoritative just because it's coming from a supposed expert. Noting my time, I will now move on to our secondary submission, whether Dr. Lung's evidence is relevant under Section 55, or alternatively, if it meets the substantially affect standard in Section 108C. For Section 55, there needs to be a logical relevance between Dr. Lung's evidence and the circumstances of the offence, whereas for Section 108C, there is a more stringent standard that Dr. Lung's evidence must have a real and compelling connection to the assessment of BH's credibility and not be merely logically linked. We submit that these two legal standards cannot be met for two reasons, reflecting the two different types of categories of evidence, as previously discussed, was admitted by Dr. Lung. First, in relation to dot points 1, 2, and 3, we understand that this evidence was used to explain to the jury counterintuitive behavioural responses of child sexual abuse and therefore could have a credibility purpose. However, what we contest is that it was too general in nature and cannot meet the legal threshold of substantially affecting the assessment of BH's credibility. Second, in relation to dot point 4, once again, because of the meaningful distinction as it relates to the conduct of perpetrators and not a victim's behavioural response to abuse, this evidence cannot meet the legal threshold of substantially affecting BH's, who's the victim, credibility. Moving to the first issue of generality, in relation to dot points 1 to 3, we submit that he spoke too generally about victims of child sexual abuse and did not provide information on how victims in the specific circumstances of BH's abuse would have responded. For example, a child assaulted by a family member or a child assaulted by their teacher could have very different behavioural responses to a child assaulted by another child, as seen in this case. Your Honour, noting my time, could I ask for a 1-minute submission, extension of time?
Yes, you have that time.
Thank you, Your Honour. For example, in MA against the Queen, the expert gave evidence on why victims abused by a family member are likely to delay in disclosure and spoke about factors such as not wanting to split up the family or needing a home to continue living in. These factors would not be relevant in this case as it's between a child and a child. And this demonstrates precisely the importance of why Dr. Lung's evidence needed to be more specific to the circumstances of how victims who are children and abused by other children respond. Moving now to the relevance of the grooming and raising circumstance evidence. This is irrelevant because it addresses the general pattern of behaviour of perpetrators and not the behavioural responses of victims. In SLS against the Queen, the court held that evidence about the role of grooming goes to explaining the behaviour of the alleged offender and does not touch upon the credibility of the victim, and therefore this type of evidence would not be admissible under Section 108C or 55. Thus, due to the two reasons that we've stated today, that the evidence is too overly general and that dot point 4 goes to the perpetrator's behaviour and not the victim's credibility, Dr. Lung's evidence as a whole cannot rationally or substantially affect the assessment of BH's credibility. May it please the court.
Thank you. And yes, next we have Junior Counsel, Ms. Mathias.
May it please the court. Your Honours, I will address ground 1 of the appeal concerning the common law presumption of dolly incapacity. That is, that prima facie, a child between 10 to 14 is presumed not to have criminal capacity. And the onus is on our learned friends, the Crown, to adduce the evidence that could rebut this presumption beyond reasonable doubt. We submit today that per section 6, subsection 1 of the New South Wales Criminal Appeal Act, this appeal should be allowed and the verdict of the jury should be set aside on the ground that is inconsistent, cannot be supported, or is unreasonable having regard to the evidence as a whole. So even if Your Honour is not satisfied that Dr. Lung's evidence was inadmissible, the conviction still cannot be sustained.
Could I just ask you something about your ground of appeal? And I think you correctly identified that the real ground is unreasonable and not supported by the evidence. The way it's framed in the notice of appeal is inconsistent with the evidence. Would you seek to amend that ground to bring it in conformity with the way you've just put it?
Yes, Your Honour.
Thank you.
Your Honour, we draw on the principle from and against the Queen in this appeal that if the court finds that the evidence is inadequate, such that a jury could not have been satisfied as to legal guilt beyond reasonable doubt, then the verdict is to be set aside. And it is our submission today that the evidence that we have before us, considered holistically, can go towards a number of plausible conclusions about what this appellant knew. And to that effect, the prosecution must exclude any reasonable hypothesis consistent with doubt to uphold this conviction. Your Honours, the appellant in this case was a child aged 12 to 13 years, and as such, the common law presumption is rebutted. This presumption can only be rebutted by strong and pregnant evidence that proves that RM knew that what he was doing, had actual knowledge that what he was doing was seriously wrong by the standards of the ordinary reasonable person, as opposed to merely naughty or mischievous. And in this exercise,
Miss Mathias, could I ask for some further unpacking of that distinction? So what distinguishes between understanding that something is seriously wrong versus merely seeing that or perceiving that the conduct is naughty or mischievous?
Yes, Your Honour. In order to distinguish that, the test is that the appellant had to appreciate the nature and effect of the act such that it would seriously offend the rules of society as exemplified by the ordinary standards of reasonable people. It's the line between expecting perhaps disapproval from parents, that would be considered merely naughty or mischievous, as opposed to understanding in a holistic sense that it's seriously wrong, such as that it would offend society or the rules of society.
Thank you.
Well, what do you make of the fact that the evidence the complainant gave was that that your client said he mustn't tell anyone because they would both get into serious trouble?
Your Honour, it's our submission that it is important not to place too heavy an emphasis on the language that is being used by a child, and this was discussed in this court in BC against the Queen in 2019, that a child may use more serious language simply knowing that it's more likely to secure the other person's silence, but this is consistent with them believing that something is naughty in the sense that their parents might disapprove. It can't go towards proving that it's that they understood that it was seriously wrong in the moral sense that by an adult reasonable standard, it would be disapproved of by society. And Your Honour, this is precisely the issue that we take with the evidence today, and that's that it is equivocal. It can be read in different lights, and to the extent that these plausible alternatives exist, the prosecution hasn't rebutted the presumption beyond reasonable doubt.
Can I push that point a little bit further, Miss Mathias? What is the impact, if any, of the evidence that also indicates that your client delivered threats to the complainant?
Yes, Your Honour. A similar reasoning process has been applied by the courts in relation to threats. Again, that they go towards perhaps proving that an appellant knew something was naughty to the effect that they would take actions to conceal it, even including threats, but that in and of itself, this cannot be sufficient to rebut the presumption. And if I might use an example, Your Honour, of the Crown against JA. In this case, there was very serious threats, including the presence of a knife and thus the threat of violence, and the verbal threats, including lie down or I will rape you. And the court in this instance found that they could not make a conclusion on the ground of dolly incapacits merely on the basis of those threats. What they had to do was to look at direct developmental factors about mental maturity, understanding, to be able to situate these threats. And in this case, as we have per paragraph 2.11 of the facts, if I may take Your Honours there.
Yes.
Appellant did not adduce any evidence as to the maturity of this complainant. And
What kind of evidence might they have led about that? I mean, what would be available to police about the maturity of an accused person unless he participated in some sort of conversation or interview with police?
Yes, Your Honour. Your Honour is very right in suggesting that police interviews can be considered as direct evidence. But further, Your Honour, the courts have considered detailed psychologist and school reports, not to the extent that we have in this case, where it simply is a skeletal statement that says the appellant was academically gifted, but more so to the sense that it reveals that the appellant knew his conduct to be seriously wrong. So, for example, Your Honour, in the case of AL against the Queen, heard in this court in 2017, the court was able to consider that the school reports revealed that the appellant had studied the subject of PDHPE, and in that subject there had been lessons on moral and sexual development and the nexus between the two. And that was the kind of strong and pregnant evidence that went towards developmental maturity, such that it related to understanding that serious sexual acts could be deemed wrong by the standards of society. And Your Honours, if I might stay on that point about evidence going towards the development, the two categories of evidence that this court can consider is first, direct evidence going towards actual moral knowledge, which we don't have. And second, circumstances from which inferences can be drawn, but only to the extent that inferences can be drawn beyond reasonable doubt. And what we have in this case, Your Honour, are two fairly skeletal statements adduced by the prosecution and some background facts. The first being in clarifications B.2, if I may take Your Honours there.
Yes.
That the development of the appellant was unremarkable. Your Honours, as the presumption is that children from 10 to 14 do not have capacity, the prosecution would effectively have to prove that RM's development was remarkable to the extent that he had the moral knowledge which children are presumed not to have. And our submission here is that we cannot draw conclusions from an absence of evidence. To say that the appellant was unremarkable places him squarely within the operating ambit of the presumption and does not go to rebut it. And this also applies to the second statement and in clarification B.1, that the testimonies of his teachers and parents revealed that he was academically gifted. And in the case of C against the DPP, Lord Lowry found that it cannot be taken to guarantee any level of moral knowledge. Because a child who is, say, gifted in maths cannot be taken to understand the moral seriousness of sexual offences. And it's particularly problematic in this case because there isn't anything positively adduced to compound this evidence of academic giftedness. The courts in Australia, and especially in RP against the Queen in the High Court, have only considered the converse, and that is intellectual disability as a factor which complicates the consideration of circumstances and raises the bar even higher. But the bar cannot be lowered by evidence of academic giftedness. And that's our main submission on the operation of the presumption. The factors relied on by our learned friends to compound evidence of this academic prowess is that the circumstances lead to evidence that this appellant has a good home life. But respectfully, Your Honours, this is not a conclusion that can be drawn from the facts or sustained to rebut the presumption. In particular, our learned friends raise the fact that RM walked BH home from school and that his family often socialised with neighbours. But at the highest, Your Honours, we can take these statements at face value. And that is that RM was given a certain level of responsibility, which is often afforded to children, but it doesn't point to any understanding that his conduct was seriously wrong in a moral sense. And to draw that link is something that this court cannot do beyond reasonable doubt without other compounding factors such as those present in AL against the Queen. And so it is our submission today that the onus was on the prosecution to positively adduce the evidence that, when looked at as a whole, could rebut a presumption which was intended to provide legal protection for children with regards to the criminal law. And respectfully, they have not done so. And thus we ask that today this appeal is allowed. If I may be of no further assistance to this court, may it please the court, those are the submissions for the appellant.
Thank you, Ms. Mathias. Now, I think that brings us to the case for the respondent. And Ms. Jones, you're going first, is that right?
Yes, that's correct, Your Honour. May it please the court. This case concerns the conviction of RM for sexual offences against BH. At trial, the Crown adduced evidence of RM's academic ability and upbringing in order to successfully rebut the presumption that RM was dully incapacitated at the time of the offences. The Crown also adduced evidence of Dr. Lung, a criminologist, an expert in child behavioural responses to sexual abuse. It is our position that the conviction of RM should be upheld, as there was no substantial miscarriage of justice. I will respond to ground 2 of the notice of appeal. On that ground, we make one submission. that the Honourable Trial Judge's finding that Dr. Lung's evidence was admissible should not be disturbed. My learned junior will respond to ground 1 of the appeal. On that ground, we also make one submission, that Her Honour correctly concluded that the presumption that the appellant was dully incapax at the time of the offences had been rebutted beyond reasonable doubt. Being opinion evidence, Dr. Lung's evidence on the behavioural responses of victims of child sexual abuse will be inadmissible under the opinion rule in section 76 of the Evidence Act, unless it falls into one of the exceptions to that rule. At trial, Her Honour ruled that the evidence was admissible under section 79, or alternatively, under section 108C of the Evidence Act. It is our position that the evidence meets the threshold test of relevance in section 55 of the Act, and that it also met the conditions to be admissible under either or both of the aforementioned exceptions to the opinion rule.
How was evidence about the role of grooming relevant in this case?
Your Honour, contrary to our learned friend's submission, Dr. Lung's evidence in entirety was relevant, including the evidence about grooming, because it could rationally affect the assessment of a fact in issue in the proceedings, namely the commission of the offence, or in other words, the physical element of the offence that the Crown had to prove.
But was there any element of grooming in RM's conduct towards BH? It seems rather to have been opportunistic than the kind of grooming behaviour we sometimes see.
Your Honour, we submit that the nature of the offending included a game between the appellant and the respondent, and that may possibly have been characterised as grooming. However, even if the evidence about grooming did not specifically pertain to an aspect of the offending, all that is required for evidence to meet the threshold test of relevance is that it could affect the assessment of a fact in issue by adding something to the jury's understanding, such as context or education. And that was something that was noted by the High Court in Smith against the Queen, which was decided in 2011 and reported in volume 206, page 650 of the Commonwealth Law Reports. And at this point, may we confirm that we have the court's permission to dispense with formal citations for the whole court?
Certainly.
Thank you, Your Honour. In Smith against the Queen, it was noted that the threshold test for relevance is quite a low threshold to pass, and questions of prejudice or other exclusionary rules are decided after the threshold of relevance had been met. So, Your Honour, I will shortly come to the other issues that our learned friends have raised with Dr. Lung's evidence. However, bearing in mind the inclusion in section 79 and section 108C of subsection 2, which specifically envisions the provision of general evidence surrounding behavioural responses to child sexual abuse, we submit that Dr. Lung's evidence, taken in its entirety, was relevant to the jury's understanding of the facts in issue. And as noted in MA against the Queen, the circumstances surrounding child sexual abuse are not matters of common knowledge. And in support of this submission, we would also note that there have been reforms to the law of evidence in the manner in which it deals with sexual assault. And one specific example of that is subsection 2 of both of those provisions. Given that the clarifications at D.2 indicated that there were no eyewitnesses, the assessment of the probability of whether the physical element of the offences occurred depended entirely or almost entirely upon the credibility of BH as a witness when he gave evidence at trial. Therefore, credibility evidence about the complainant indirectly affects the assessment of a fact in issue, and it is sufficient in order to pass the threshold in section 55 that evidence indirectly affects the assessment of a fact and issues. Your Honour, we submit that it is important not to conflate the test for relevance under section 55 with the requirements of admissibility under section 108C, which are more stringent. And we note that our learned friends have made reference to section 108C and have submitted that Dr. Lung's evidence could not substantially affect the assessment of the credibility of BH. However, we submit that it could do so. And in support of this submission, I would draw your Honour's attention to our written submissions at 2.3, where we submit that an alternative base for admission of the evidence is section 108C of the Evidence Act by way of an exception to the credibility rule in section 102.
In this case, Ms. Jones, the expertise of Dr. Lung was derived exclusively from his research. What basis was there for the primary judge, the trial judge, to think that he had any relevant experience in the impact on a child of sexual assault by another child? Was there any aspect of his research that was relevant to that particular kind of case?
Yes, Your Honour, there was. We submit that our learned friends' submission that Dr. Lung's evidence went beyond his field of expertise was unduly narrow, because the clarifications at C.1 indicated that the Crown led evidence relating to Dr. Lung's publications, and his publications specifically relating to the behavioural responses of victims of child sexual abuse.
But my question was directed to victims of child sexual abuse perpetrated by children. A lot of the standard behavioural responses are commonly associated with assault by adults, such as grooming. One doesn't readily think of children as being sophisticated enough to engage in grooming kind of behaviour. How was Dr. Lung qualified to speak to assault by a child?
Your Honour, Dr. Lung was qualified to do so because he has conducted empirical studies, including surveys and interviews with victims of child sexual abuse. And although it's not noted on the fact that he specifically interviewed children who had been abused by another child, we submit that all that is necessary for his opinion to be admissible under Section 79 is that it is based on specialised knowledge, and we submit that in this case, Dr. Lung's evidence was based on specialised knowledge.
So you just say the absence of any specific reference to any research about assault on children by children is a matter that would go to weight rather than admissibility?
Yes, that's correct, Your Honour. The issue before the court today is whether the evidence was admissible under Section 79 or alternatively under Section 108. And all that is necessary is specialised knowledge and that the opinion was based on that knowledge. As Section 79, subsection 2 of the Evidence Act makes clear, there is a body of expertise based on the impacts of sexual abuse on children and behavioural responses to sexual abuse. And we also draw Your Honour's attention to MA against the Queen to support this submission. In that case, the court held that evidence of a child psychiatrist was admissible to explain the psychological factors influencing the complainant's behaviour surrounding the alleged offences. And paragraph 2.9 of the facts verifies that Dr. Lung had specialised knowledge in the area of children's behavioural responses to sexual abuse at the time of the trial, since he had published over 100 journal articles on the topic and on account of his qualifications in criminology and psychology.
So Ms. Jones, in the case of MA, though, is it not distinguishable from the present case that the expert had clinical experience, whereas in this case, Mr. Lung only had research experience?
Your Honour, we acknowledge that, yes, in MA, the expert did have clinical experience. However, we submit that the admissibility of his evidence did not turn specifically on his clinical experience. The court went through the two limbs of the exception to the opinion rule in section 79 and found that he had specialised knowledge not only derived from his clinical experience, but also from his research and qualifications. So, furthermore, Your Honour, we submit that the wording of the provision in section 79 indicates that the specialised knowledge must be derived from training, study or experience. The inclusion of the word or indicates that it is not necessary for the expert to possess all three.
But wouldn't you want to consider that issue in the context of the facts of the particular case, so that here, where the issue is the credibility of a child, that feels like the kind of issue that you would learn more about from clinical experience than research?
Again, Your Honour, we submit that this is an issue that would go to weight rather than admissibility. So it would be, it may be the case that the jury would decide to give less weight to an expert who lacked clinical experience rather than an expert who was like the expert in MA who did have clinical experience. However, the issue before the court today is whether the requirements of that provision has been satisfied. And as was indicated by the majority in paragraph 3 of Untitled against the Queen, the provision does not require anything further than the witness having acquired specialised knowledge from either training, study or experience. In that case, the court even indicated that a person without formal qualifications may acquire specialised knowledge simply through experience. Now, of course, in this case, Dr. Lung does have extensive formal qualifications, extensive research publications, and also empirical research directly involving contact with victims and survivors of child sexual abuse. However, we cite Honeysett to indicate that there is no prescriptive requirement in the provision about the threshold for specialised knowledge that must be met beyond either training, study or experience. Anything else goes to weight rather than admissibility. Your Honour, in our learned friends' written submissions, they submitted that Dr. Lung did not disclose the intellectual basis for his conclusions, and thus his opinion given at trial was not based on specialised knowledge. However, clarification C.1 indicates that Dr. Lung drew on the relevant findings of his research into behavioural responses of victims of child sexual abuse to explain to the jury the matters listed in paragraph 2.8 of the facts, such as how victims may delay in reporting abuse and why victims would continue to interact with the perpetrator following such abuse. This indicates that he followed the necessary process of demonstrating how he applied his specialised knowledge to the observed or assumed facts and came to the opinion.
I think what would worry me about the clarification the material contained in the clarification is that a lot of his experience is something that the appellant can't test. For example, the empirical studies, how is the appellant to test that kind of expertise? If he was speaking of clinical experience, they could pin him down to particular kinds of cases and experience, but where he's just reading the research of others, that makes it more difficult, doesn't it? Is that a matter that goes to admissibility? It certainly goes to fairness.
Anna, with regard to the need for the jury to be able to test the conclusions, we submit that in this case, it is distinguishable from cases such as R against Tang, in which the problem that Your Honour noted did arise, because in that case, the witness made conclusions in her opinion given at trial about whether the CCTV footage taken at the time of the alleged offences showed the defendant. So in that case, it involved a witness giving evidence in front of the jury and saying something that amounted to the person in the CCTV was probably the defendant. And so in that case, the witness's opinion was ruled to be inadmissible because there was no sufficient basis by which the jury could test the accuracy of her conclusions. This was also an issue in the case of Dasreef and Horcha. And again, in that case, the opinion given by the witness involved numerical calculations, which were held to be inadmissible because, again, there was no basis for the jury to test the accuracy. However,
how is Dr. Lung's evidence different from that kind of problem?
We submit that it's different because it doesn't involve coming to a conclusion about calculations, and it doesn't involve coming to a conclusion about whether the offence occurred or whether the credibility of the witness could be established. Dr. Lung, in fact, didn't say anything at all about whether BH was a credible witness. His evidence educated the jury on matters relating to behavioural responses to child sexual abuse, which are not common knowledge. And as noted, by the inclusion of subsection 2 into both of those exceptions to the opinion rule, there is a place in the law of evidence for a witness to give evidence about matters of child sexual abuse, which are not matters of common knowledge and which, if not addressed, may lead the jury into misapprehensions. In this case, the possible misapprehensions involve conjecture about BH's delay in reporting the alleged offences and his continued interaction with RM following counts 1 to 4. In MA against the Queen, expert evidence was tendered for this very purpose and was held to be admissible under section 108C. The court held that this specific type of evidence about behavioural responses to child sexual abuse satisfies the requirements of subsection 2, as the complex and varied dynamics of sexual abuse do not typically form part of the ordinary knowledge of the jury. If I may be of no further assistance to the court, that concludes the submissions of senior counsel for the respondent on this point.
Thank you. I'll just check with Justice Shackle whether she had any further questions.
No, I don't at the moment. Thank you.
Thank you. Thank you.
Thank you, court.
All right. And then Ms. Donovan.
May it please the court. Continuing on from my learned senior, I will address submission 1 of the respondent written submissions in relation to ground 1 of the appeal. Namely, that the evidence at trial was capable of rebutting the presumption that the appellant was Dolly Incapax beyond reasonable doubt. The High Court's 2016 case of RP against the Queen affirmed that the presumption that children under 14 years of age lack the capacity for mens rea is in fact rebuttable, so long as the child is aged above 10. Due to the appellant being aged 12 to 13 years during the charged offences, as evident at 2.1 of the facts and A.2 of the clarifications, at trial, the respondent had the opportunity to adduce evidence to prove that the child possessed the ability to distinguish right from wrong. We submit that the evidence was sufficient to establish that the appellant was intellectually and morally developed to such an extent that they could comprehend the gravity of their conduct in the circumstances. This court's 2017 decision in AL against the Queen established that the presumption will be rebutted beyond reasonable doubt, where it is shown that the child has the capabilities to comprehend that their actions were something that was morally wrong.
What do you rely on for the aspect of moral judgment? We know that he was above average intelligence, but does that sound in the capacity to make moral assessments?
Your Honour, we submit there are 3 factors relevant to the question of whether or not the child knew that what their actions were in the circumstances was something that was morally wrong. The first is that of academic intelligence. The second of that is moral education through socialisation and community upbringing. And the third is that of the circumstances of the offences. We submit that when the 3 of these are combined, they are sufficient to rebut the presumption beyond reasonable doubt.
So I'm wondering, Miss Donovan, if we focus on the circumstances of the instant case, is the fact that BH in this case did not overtly demonstrate distress, and that he seemed to acquiesce to RM's conduct. Is that a relevant point for consideration in terms of the question at hand?
Your Honour, in the case of RP, the victim's reluctance to engage in the activities was a relevant circumstance. However, the court noted that that is only one of many circumstances that can turn to the mindset that a child knew what they were doing was something that was morally wrong. In the circumstances, we submit that the lack of reluctance by BH is not determinative of the child not having the capacity to recognise that what they were doing was something that was morally wrong.
And what about, I'm troubled by this notion, if I could come back to it, of his being academically gifted. It doesn't experience tell us that often academically gifted people are the ones who are less capable of reading social norms and understanding what's acceptable and what isn't?
Yes, Your Honour. We submit that alone academic intelligence would not be sufficient for moral comprehension. However, we do submit that evidence of academic intelligence allows the child to have advanced reasoning skills, such that this does tend towards the conclusion that they had the heightened ability to distinguish between right and wrong. This was also considered in the case of AL, where combined the evidence of the child's academic abilities in relation to their studies, in addition to growing up in a community environment, and also considering the circumstances of the offences, this was sufficient to rebut the presumption.
And can I ask Miss Donovan, is there any case law that talks more specifically about understanding the wrongness in relation to sexual offending specifically?
Your Honour, we submit that the case of AL discusses exactly that of knowledge of moral wrongness in relation to sexual offending. And we submit that the circumstances of AL, being that the older child was aged 12 to 13 years and the victim being aged 5 to 6 years, those also being neighbours in that case, is very similar to the current circumstances. We submit in that case, the presumption was rebutted, and due to the similar circumstances in that case, in regards to the circumstances that we also have before us, that this case is a parallel, and hence the 3 factors of academic intelligence, community upbringing, and the circumstances will be sufficient to rebut the presumption.
Thank you.
What do you say in response to the argument that was put by junior counsel for the appellant, that as to the circumstances, the offences, that the very fact that we're dealing with this question of Dolly Incapax tells you that you would place less weight on the words chosen by a child, so that when a child says don't tell anyone or we'll be in really serious trouble, you give that less weight for the very fact that it's a child saying it, and that's the question we're all here to consider.
Your Honour, we submit that the case of BC, which was cited by our learned friends, more referred to the fact that the court should not place emphasis on the specific pronoun used by the child in the case, such as distinguishing between I will get in trouble or we will get in trouble. However, in the cases of RP and L, the court has taken into account the language used by the child and whether or not their perception of their actions in the circumstance can turn towards the conclusion that they knew what they were doing was something morally wrong. Here, we submit that the appellant's language at 2.4.1 of the facts, including huge trouble, bad stuff, and the need to keep the act a secret, is support for the appellant's knowledge that his actions were seriously wrong, as he was already anticipating the repercussions of his actions at the time of engaging in the sexual behaviour. This choice
Sorry, which paragraph of the facts was that you just took us to?
That's at 2.4.1 of the facts, Your Honour.
Yes.
We submit that this choice of words to describe the child's own perception of their conduct turns to the conclusion that the appellant knew their conduct was something that was morally wrong. In addition to this, per 2.4.2 of the facts, the appellant immediately ceased the conduct upon any indication that he was going to be caught, again demonstrating an ongoing understanding that his acts were seriously wrong. In further contrast to the appellant's submission that the child's attempts to secure the silence of BH only denotes that he wanted to conceal the acts from parental authority, the evidence demonstrates that the appellant's conduct extended beyond mere childish play. The facts at 2.5 and 2.6, providing that the appellant consistently issued threats to BH over a 2 to 3 year period, whilst the acts were occurring so as to secure his silence, which illustrates the elaborateness of his efforts to conceal the conduct, of which does affirm the conclusion that he perceived his behaviour to be something morally wrong. This submission is aided by the conclusion of the court in AL, where due to the repeated issuing of threats over a period of around a year, the child in that case was held to have knowledge that what he was doing was something morally wrong by the standards of society.
Ms. Donovan, how do you respond to the concern that those threats, though, followed the offences, so they were not contemporaneous with the offences, and so given that the threats occurred at a time at a later point in time, how does that go to demonstrating awareness or perception of wrongfulness at the time of the actual offences?
Your Honour, we would combine the threats issued at the time of the conduct occurring, in addition to those subsequently issued by the appellant at social gatherings such as the barbecue. This demonstrates an ongoing understanding that the conduct that had occurred was something that was morally wrong. This was a consideration by the court in AL, where the repeated issuing of threats to keep quiet turned towards the mindset of the child that they knew in the circumstances it was morally wrong.
Mightn't it also indicate, alternatively, I should say, indicate some embarrassment about sexual behaviour at that age, or embarrassment about homosexuality, or, I mean, you have to exclude any reasonable hypothesis consistent with innocence.
Yes, Your Honour, we submit that the language of huge trouble and very big trouble turn only to the mindset that the child knew their conduct was something that was morally wrong by society. Further, the sinister and escalating nature of the threats supports this conclusion, as the threat that the appellant was going to kill BH's dog, as quoted at 2.6 of the facts, reaffirms the extent to which he was willing to act to conceal the behaviour, of which turns to the mindset that he thought what he was doing was something that was morally wrong, as opposed to being merely embarrassed. Such a grave threat would not result from conduct that the child only thought was embarrassing.
Yes.
Contrary to the appellant's submission that the circumstances only turn to the mindset of the child that their actions were naughty, the circumstances of counts 1 to 4 at 2.4.1 of the facts and D.2 of the clarifications provide that the acts were carried out in seclusion, away from any witnesses, in a deliberate attempt to ensure that no one observed the conduct, of which demonstrates that the child knew what they were doing was morally wrong. This is elevated in counts 3 to 4 at 2.4.2 of the facts, where the appellant chose his own home as the location for the sexual acts, whereby he had control over the surrounding environment so as to take all measures to avoid detection and listen for anyone who may be approaching, evident when he instructed BH to quickly pull up his pants when they heard someone approaching. As noted by the court in AL, this heightened sense of secrecy, the efforts to ensure seclusion, and the attentive behaviour is a determinative factor in reaching the conclusion that the child believed their actions were something that was morally wrong, as opposed to something that was merely naughty. Your Honours, returning to the point of the social upbringing of the child, in RP, a significant factor in finding that the presumption of Dolly Incapax could not have been rebutted was that the child in that case had experienced childhood turmoil and dysfunction and educational and social deprivation, of which had hindered his ability to understand that his conduct in the circumstances was something that was morally wrong. In contrast to the appellant's submission, that evidence of an unremarkable upbringing cannot demonstrate capacity to comprehend wrongdoing, as it makes general assumptions about children. The evidence rather demonstrates that the child in this case did not experience any circumstances that would prevent him from being able to comprehend and understand the clear distinction between acceptable behaviour and morally wrong conduct. This is akin to the case of AL, whereby due to positive evidence of being raised in a family and community-orientated environment involving regular interactions with others, as evident at 2.4.2 and 2.6 of the facts, the appellant would have acquired an understanding of social norms, as a child's upbringing constitutes a form of moral education. As the court held in AL, absent any disadvantage or deprivation, and especially in the face of clear evidence to the contrary, a child with heightened academic performance and a good home life will be seen as being able to understand the distinction between right and wrong behaviour. Contrary to the appellant's submission that evidence of intelligence and upbringing was insufficient to rebut the presumption, there is ample authority for the proposition that information regarding a child's home environment and their academic performance from a teacher's perspective is capable of establishing the child's maturity, proving that they knew the difference between right and wrong, and rebutting the presumption beyond reasonable doubt. The cases of RP and AL, in addition to the House of Lords 1996 case of C, a minor against the DPP, and this court's 2006 decision in BP and SW against the Queen, all commented on the capacity for evidence from a teacher to provide an insight into the child's development. And
the evidence in this case, though, was pretty thin, wasn't it? I mean, we can accept that such evidence could be helpful, but in this case, what do you point to as giving your case support?
Your Honour, we submit that giving support to the submission that the child was academically gifted was that given by a teacher at the time and also parents and family members of the accused.
Just remind me what the evidence of the teacher was. Where's that in the facts?
Your Honour, that is located at paragraph 2.11 of the facts, in addition to B.1 of the clarifications. We submit, as was the case in AL, where there was evidence of school reports, which turned towards the conclusion of the child's academic talents. We would submit here that the evidence given by this teacher and the family members that the child was academically gifted is a factor that is relevant to go towards the rebutting of the presumption, as the child had heightened capabilities to distinguish between right and wrong.
Well, he might or he might not. He might have a heightened capability to prove a mathematical theorem, but I just come back to my question whether academically gifted people are necessarily people who have a good understanding of social norms or reading people.
Your Honour, we acknowledge that being academically gifted alone is not sufficient. However, we submit that in conjunction with the child's social upbringing and the circumstances of the offences, this is sufficient to rebut the presumption, and acknowledge that they understood in the circumstances what they were doing was morally wrong. High Court 1990 case of Shepherd against the Queen and 2007 case of the Queen against Hillier establish that in determining whether a proposition has been proved beyond reasonable doubt, the evidence should be considered cumulatively. It is not a question of whether every circumstance can be proved beyond reasonable doubt or satisfy this high threshold. Given the facts at 2.5, providing that the conduct was an enduring sequence of events over 2 to 3 years, there is a need for the court to take a holistic approach. Contrary to the appellant submission that the evidence is equivocal, we submit that the evidence provided by a teacher and close family members that the appellant was academically gifted, and the evidence of the child's home life and moral education through their socialising, in addition to the circumstances of the offences, including the issuing of threats, the attempts to conceal the conduct, and the specific language, all amount to a rebuttal of the presumption that the appellant was dolly incapax beyond reasonable doubt, as he had the capacity to distinguish right from wrong and knew in the circumstances that his conduct was something that was morally wrong as opposed to merely naughty. If I can be of no further assistance to the court, that concludes our submissions on this point. The relief we seek is that the appeal be dismissed.
Thank you.
Please.
Now, is it appropriate for your leader now to respond to the appellant, and then we'll call on the appellant to respond to your submissions? Yes.
Sorry, Your Honour, could you clarify the order? Would the
well, you do whatever order you prefer. If you've already agreed in which way you want to do it, that's fine.
May it please the court. It has been put to us that Dr. Lung's failure to identify and explain the specifics of the basis of his opinion from his fieldwork goes to weight and not admissibility. We respectfully disagree with our learned friend's formulation of the law on this issue. Matinka Propriety Limited and Sprouse, heard in the New South Wales Court of Appeal, specifically states that the facts that form the basis of an expert's opinion must be identified and explained. That is to say, Dr. Lung needed to identify what topics the surveys and interviews covered and the results of his fieldwork that he relied on to form the basis of his opinion. In the absence of such identification, we cannot conclude that he wholly or substantially based his evidence on specialised knowledge that pertains specifically to the behavioural response of child sexual assault victims. This is a crucial legal error as it means the evidence is inadmissible under Section 79. This is even more significant in this case as our learned friends relied heavily on his fieldwork to justify his lack of experience. Therefore, Dr. Lung's evidence is inadmissible under Section 79.
Yes, and Ms. Jones?
May it please the court, 1 point in rebuttal. The respondent submitted that the lack of exposure of reasoning process goes to weight rather than admissibility. and that Dr. Lung needed to identify the facts on which his opinion was based. This is an error of fact because Dr. Lung referred to the results of his research in explaining the matters listed at paragraph 2.8 of the facts to the jury. Furthermore, there is authority in cases such as HG against the Queen and Dupas against the Queen for the proposition that exposure of reasoning process will go to weight rather than visibility. May it please the court.
Thank you, Ms. Jones. Now, it's my understanding the court will adjourn for a short time to consider our decision. It's my understanding that we could be given a breakout room for that, or alternatively, we could just mute and go off the screen because we have each other's phone numbers. Justice Shackle, do you have a preference?
Perhaps at this point we might mute and even turn off our videos and speak
Sure.
by phone.
Sure, okay, I'll do that.
Thank you.
So the court will adjourn for a brief time.
Olivia. Let's do it. Rock and roll. Party, here we go.
Hello.
Hello. Hi.
How are you all going?
Good. Excellent.
Feeling better now? So we have discussed our decision, and I'm just wondering, I wasn't sure whether there was a time issue that we needed to wait until 7 or whether we're able to proceed now. Are the organisers able to clarify that for us?
Oh, Your Honours, we're happy to proceed with the awards ceremony now, and if you already know who has won the Moot and who you have identified as the best speaker, we would be really grateful if you could type it to me in the chat or email it or text one of us so that we're quickly able to put that in the PowerPoint that we've just prepared for today.
Okay.
If that is
So
all right.
can I email that to you?
Of course, Your Honour.
Okay, I'll just go off screen and do that.
Thank you.
Just to break the silence, you were all brilliant.
Thank you.
Very well done. Very impressive all round.
Thank you very much.
Okay, I've just sent that to the Moot email address. Is that right? The SULS Women's Moot address?
Yes, Your Honour.
Good. Okay, let me know if you've received that.
Your Honour, I can confirm that we've received it. I'm just populating it right now into the PowerPoint. So
Great. Excellent. Excellent. It's the COVID equivalent of handing you the envelope. Very, very dramatic. All right. So you let me know
maybe
when
some
you're
general
ready.
Comments.
Yeah.
How about we just do some general comments and then we can go ahead once the PowerPoint's uploaded with the formalities.
Cool. Okay, excellent. And I heard Professor Shackle saying just now as I was sitting at my email that as a way of filling the silence that you were all excellent, and that was the first thing that we agreed on when we spoke just now in our breakout room, is that we both felt overwhelmed and uplifted and really quite amazed by the overall standard. You were all absolutely incredible. I have been sitting listening to barristers experienced counsel try to come to terms with the technology of Zoom and also maintaining their standards of advocacy, and you, all four of you, were just extraordinary in your presentation. You were calm, you were composed, you were considerably clearer than a lot of barristers who mumble into their cups of tea as they try to deal with the new technology. But more than that, the content was also of a very high standard. I felt that all four of you engaged in an intelligent way with the issues, and I know I'm speaking for Professor Shackle as well as myself in just saying we were blown away by the standard, and there was very little to separate you, and we commiserated with ourselves at the fact that that we're not allowed to call it a draw, as they say. So we did have to find some points of distinction based on the very clear marking system that the rules provide, and that enabled us to draw some very fine distinctions between you, but you were all extraordinary. We did also discuss the fact that it's possible that the topic lent itself, the topic of expert evidence, I think, is a bit drier, and I think that the topic of the Dolly Incapax principle might have lent itself to a bit more Socratic exchange with the judges. So that was mindful of that distinction. My screen's just gone. Can you all still hear me?
Yes.
Yep, good. Okay. I've got you back now. And we were also both very impressed at the way that you were able to navigate a combination of areas of the law. That the question took you through considerations of evidence and also substantive law, and you all had a good command of the authorities, and you were able to navigate across those different areas of the law in a way that was fluid and persuasive. So it was all very impressive. I have been asked to also give some personal reflections, and I'm going to keep you all in suspense just for a couple of minutes to say something about that. I think I just wanted to reassure you all, the whole point of this competition is to encourage women in advocacy. The first thing I wanted to reassure you all is that every one of you is of a standard of advocacy that you could consider going to the bar, and I hope you will. And I mean that. I'm not just saying that because you've come along to a moot. You are all very impressive, and you should all think about a career at the bar, because if you saw some of the advocates we see, and if you saw yourselves on screen tonight, you would see that you are of a very high standard, and you should think about it. I hope you will. And I just also wanted to reassure you that I don't know how to say this without sounding as though I'm sort of lording it over you with experience, but I know that I'm in a position now where people think, you know, that I've done okay. And there wasn't a day go by when I was at the bar where I didn't wonder whether I was strong enough and good enough. So if you have those feelings and those negative voices in your head, chase them away, because they don't mean anything. I've seen all four of you, and if you have any self-doubt, you shouldn't, because you're all amazing. But I wanted to reassure you that I don't know if it is more a female thing, but I certainly, even where I am now, I have days where I go home and I just think, I'm not strong enough for this gig. I don't know what I'm doing here. And it's a pernicious voice, and it's not a real voice. It's just the way women sometimes beat themselves up, and I hope that you won't fall down that negative path, because you are all incredible. So with that said, without further ado, really at the end of the day, I think what distinguished the winning team was a capacity to grapple with the issues in a very fluid way, and really be across all of the issues. And as I say, in a decision in which Professor Shackle and I both agreed, but by a narrow margin, we felt that Team U, the respondent, had the edge on that. So Team U is the winner of the competition. Congratulations. We did, however, in terms of the best speaker, award that to Junior Counsel for the Appellant. And again, that was by the narrowest margin, but it's Alisha. If you could say a word so I can see you on the screen for a second. Are you still there?
Yes, I am, thank you.
Where are you? I can't see you.
Can you see
Oh,
me?
yeah. Oh, you're off the screen. Yeah. But again, as I say, it was by a very narrowest of margins, because all four of you were able to grapple with questions very well, but there was something very persuasive about the way in which you took a question on board, answered it, and kept going seamlessly into your submissions, which we both found very persuasive. So congratulations. We award to you the best speaker.
Thank you.
And then I was also asked to announce the best speaker from the preliminary round. Should I do that now?
Your Honour, may we share screen of the PowerPoint that we have prepared?
Sure.
Thank you.
That would be fun.
Thank you. Yes, Your Honour, we'd be grateful if you could announce the best speaker for the preliminary round.
So Annalise Woolen from Monash University and Team F is the best speaker of the preliminary rounds.
Thank you.
Thank you. And Your Honour, did you want to say a few more words about your experiences?
Well, I really said what I wanted to say, but I'm happy to say more if there's more that you wanted to hear. I really just wanted to convey that message about it being very, I think in some ways very different being a female advocate, because in ways that you don't necessarily recognise from the outset, you are often in an environment where you feel surrounded by men or surrounded by people who you think have come from a different kind of background, a more advantageous background. You think you might not be doing as well as other people, but that's a feeling that you should combat, because you're already, all of you proved that you're strong enough for this gig. And as I say, I often go home thinking I'm not strong enough, and it's a feeling that you should resist. I guess I would also say one of the things I think I'm very fortunate in is that I had extremely diverse experience, and that was more by good luck than good management on my part. I sort of stumbled along this accidental career path, which led me to a whole lot of really valuable experience, including that I went to Canberra for the very respectable reason that my then boyfriend went to Canberra, so I followed him and ended up landing on my feet with this fantastic job at the Canberra DPP, where I was a salaried prosecutor and I was going to court every day doing minor traffic prosecutions up to instructing in murder trials, and a whole range of experience. And I just learnt so much through that. So I think I would say, if you're wanting to get experience as an advocate, don't have it in mind that you have a particular path and that's the only path, and if you fail on that path, you're going to fail. Be prepared to go where your career takes you, and just above all, lap up any opportunity for experience in court, whether it be going to court with a barrister, sitting in the back of a courtroom watching barristers. If you know a judge or someone who works for a judge or a barrister, say, can I tag along? Ask them about their cases, read about cases, read transcripts of the High Court. Just immerse yourself in as much advocacy as you can, and get as much experience as you can, and live it and breathe it, and don't have a preconception about where your career should go. Just know that there's no right path, there's just the path that you end up following. But I have a feeling that all of you may well be following that path, and I hope you will think about it. I think Professor Shackle also wanted to say something.
That'd be great.
Thank you, Justice McCallum. Look, I don't know if I can add too much more to those insights and words of wisdom, but I'd like to start by congratulating everyone. So not only the grand finalists, but everyone who has participated in this competition. Congratulations for having the courage, and congratulations for having the initiative to make the decision to be a part of this competition and to see it through. I was very fortunate actually to receive some emails and to have had some communications with some of the judges from the preliminary rounds, some of my colleagues who just were so impressed by the teams in the other rounds. And in fact, I had a couple of my colleagues say to me that they were so incredibly inspired by listening and seeing you moot. And I have to say, I would echo that. As a professor of law, to be a part of this competition and to see you all engage with the law, not only in terms of some of the points that the Justice McCallum was making about your tremendous advocacy skills, but also your tremendous intellectual skills in terms of interacting with the materials in that very rich and deep way. And so I guess I would like to add to what Justice McCallum was saying about your career path, and perhaps put in a plug for academia.
No, come to the bar.
There's a bit of a competition, but perhaps both, because careers don't always take a singular path, and people move between different career paths. But certainly academia and legal academia also, I think, needs the insights and the tremendous capacity of young women. So don't forget academia, either as a main career path or as an ancillary career path as you navigate your future careers. I'd also like to congratulate you because of your skill in being able to moot via Zoom. I think mooting is quite a challenge in the best of circumstances, but to be able to do it via Zoom and to do it in such an eloquent and composed way is a credit to all of you. So I think that's quite noteworthy as well. And then finally, I would like to also congratulate the organisers, because I realise it's no easy task to pull a competition of this kind together, and that takes quite a lot of commitment. So congratulations for hosting this competition so successfully.
There was one further thing I forgot to mention too, which is to acknowledge the work of the instructing solicitors on the teams. Obviously, we had regard to the written submissions, and they played a role in our decision, and the instructing solicitors. And also there was the rather entertaining spectacle that we saw of, I think it was senior counsel for the respondent, whenever I asked a question or Professor Shackle asked a question, we saw from the corner of the screen a little yellow post-it note coming up. So there was some active instructing happening there. I assume it was something more than the fabulous scene in the castle where he's passing a note saying, "Want some water?" But there was some good work obviously being done behind the scenes. So congratulations there. And I should endorse what Professor Shackle said about academia. One of the finest judges this country has ever seen, Ron Sackville, began as a professor of law at UNSW, and then went on to be a barrister, and then went on to be a judge of the federal court, and then an acting judge of appeal. And so there's some complementary work to be done by both kinds of careers, and people can cross those paths. And also people might be thinking about being solicitors, having had that experience of passing the notes. So, all right. Are we done?
Yes, Joanna, thank you for
Well,
those
yeah.
words. That was very well said. Lauren, did you have anything to add?
I was just going to say, just in consideration of time, if the judges are still available to remain for the next minute or so, we were just going to post some photos from this PowerPoint. Now, we've had quite a lot of teams participate this year, so we apologise in not being able to provide photos from every single round. But just so that you can perhaps see as well, your colleagues might come up and you might recognize them in some of the shots. It was quite difficult because taking photos on Zoom is not exactly the most flattering when you can't tell people that their photos are being taken. But just to perhaps just to finalize on what the last few days have been for the students and to bring it together, I think sometimes seeing yourself, you don't realize when you're talking to a screen that you're actually the orator in you. Is it there or is it not? And I think sometimes seeing a photo, it just confirms that you've got like the capability to do maybe what you exactly, Ms. McCallum was saying, maybe you're doubting your skills. So we'll just show some photos and then, I mean, there are quite a few, I think we've got 44 now participants that are quietly watching on. I don't think we'd be able to open the floor to all questions, but maybe in a bit we'll open the floor, and if the students want to introduce themselves to other students, and judges, if you need to leave, then that's more than okay. But we just want to thank you profoundly for participating. I know that this Moot, we started it and we were told, oh, it's got a bad name, you know, it doesn't get organized well. And so we was just so frantically trying to get some judges so that the students would maybe be like exposed to that level, that caliber of, you know, experience and thinking. So I think we're just thrilled, like as a small team, that we managed to pull it off, because at times it didn't feel that way. And we're all in exams and everyone's got assessments due, and I'm sure everyone knows the feeling. So we're really, really very, very thankful. And who knows, in a few years' time, let's hope that the nature of like this intervarsity competition sort of gets a bit more of a headline and can compete with some of the bigger ones as well. Because I think there's something very valuable in female advocacy. I don't think we need to lament the point, but it's very important. So yeah, that's just what I wanted to say. Thank you so much.
Thanks.
Thank you.
I'll just show some of the pictures now. Hopefully you can see yourselves. And I think there are some mums and dads watching on. So of course you can take screenshots if you see anyone you recognize there. Yeah.
Yeah, please do. Prelim rounds. Natalie Goulder, there was the judge. And then we had Robin, I can barely see, Buer. Put on full screen. Marilyn McMahon. Some of these judges, they were excellent. Their questions were just incredible, but very difficult, almost terrifying. Oh, Catherine Greenman, she was excellent. Very thorough. Carolyn McKay, preliminaries. Roy Williams, my evidence tutor. Very thorough with his questions. Nigel Stobbs, Professor Nigel Stobbs. He's the senior lecturer at QUT. He was, oh, his questions, I was like feeling it for the girls last night. He was great.
Yes, and also special mention to Team Q, who made it to the semi-finals. That's a tremendous achievement, so well done, Team Q. It was Estelle and, yeah, Annie.
Justice Fullerton in that last semi, and we're here today, the grand final. So we'll probably send these photos around if anyone wants them, but congrats anyway, just wonderful effort. Zoom is a funny platform, isn't it? It feels so, everyone feels so distant.
So I believe now we've sort of come to the end of the formal part of this evening. So Professor Shackle and Justice McCallum, if you have other commitments, you're more than welcome to leave. And we'd like to thank you for your involvement in this year's Moot. It made a really big difference, and we were sending out hundreds of invitations, really hoping that we didn't have to cancel any of the rounds because of not having any judges. So it really, the support of female legal academics and justices like yourselves that makes this possible. So thank you again.
Thank you. And I will go if you don't mind, because I have family to get home to, but thank you very much. And
Thank you.
Hope to be involved again in the future.
Thank you.
And thank you so much.
Likewise, I will say good night and thank you again.
Thank you. We're so appreciative. Good night.
Thank you. Good night.
Bye. Okay. Who do we have left? Does anyone want to ask questions? Or do you want to meet your other teams? Congratulate them.
I might just go back to some of the earlier slides that announced the winning team and the runner-up team. So I think if family or you guys want to take a picture of that slide, you can go ahead, because I think it was announced before we had a chance to put up the slide. Is that all right?
Yeah, sure. Definitely.
How do we screenshot?
Oh, a screenshot. Yeah, I just realized I was actually screenshotting while I was sharing screen, and then I decided I should stop doing that. Sorry, I'll just go back. So, Alisha, would you like to identify yourself, and perhaps you can even say a few words if you like. Actually, it's a pretty massive achievement, and congratulations.
I think I've said many words in the course of this Moot, so I don't suppose anyone wants to hear any more. But we had some, on behalf of all of us who really enjoyed this Moot, we had a really great time over the weekend and the past few days. We went up against some really formidable opponents with some really great judges, so we're very grateful for the opportunity, and congratulations to Team U on their win tonight.
Wonderful, thank you.
And we'd like to echo that as well. Congratulations to Alisha and for all of Team K. It was a great pleasure rooting against you, and you raised some really pressing and arguments that were formidable to respond to. So yeah, thank you.
Wonderful, all right. And Team U, did you have anything else that you wanted to say as the winner of the 2020 Baker McKenzie National Women's Moot and the first virtual Moot for this one?
I think we've really enjoyed the process, and we thank the conveners as well for being very responsive to all of our questions throughout the process, and it's been a wonderful experience.
Yeah, I'm sure there was a lot of hard work that went on behind the scenes with organising and contacting all the judges. So it's very much noticed and appreciated, all the hard work that both of you put in. So thank you so much for making this competition possible. And also our coach.
Yeah, shout out to our coach.
She's wonderful.
Just curiously, of the Team U, Team K, because they're the only two video screens I can actually see, which year at uni are you all in for law school? Wondering.
I'm in my second year of the JD.
I'm in LLB 5.
Okay.
I'm in LLB 2.
LLB 2. And Team K?
We're LLB 3 and 4.
Okay, so some of you, I think that means most of you have done evidence, right?
Yeah, well,
no.
we're in the process of doing evidence at the moment.
Okay, yeah. So I was wondering when we got that problem question, the level of difficulty for all the students and what years they were in, because evidence is just notoriously one of the hardest subjects before you choose your electives. So I'm just very impressed. Like, I was listening when I had a chance on the submissions, and especially in question time, that those thresholds, those tests for every single piece of evidence is just so difficult to sometimes even wrap your head around, let alone to argue coherently. So I'm just really like pat on the back. It was such a great effort.
Thank you.
No, it's all right. I hope that also with the judges, we didn't want to release the names of the judges. I think I said this last night to the girls of Team U, but just we were worried maybe that everyone would be a little bit frightened if they knew the level of the judging in the rounds. But it's every single round we've almost had an email back to us saying the girls were fantastic. Like it blew me away, their level of arguments and their coherence. So just really reiterate to everyone that's still listening that you may think that from the questions that you maybe not doing a good job, but that's not the feedback. The feedback's been quite the opposite. It's been just really high level. Just they're so impressed with what was argued, and given their experience, and some of these people have been in the field for decades. Yeah, you should definitely continue mooting, I think. Don't stop now unless you're at the very end, but you've all got the skills, for sure.
Does anyone else want to say anything? Perhaps one of the participants who is watching or listening tonight?
I might just quickly jump in. I know that people must be wondering about their scores. A participation certificate I can see is just being posted in the chat. So we are in the process of now just obviously finally getting some time to get back to a lot of emails that we've been getting regarding scoring. Bear with us. We will try to get them out, but with the scoring by the end, at least latest October 7, but it won't take that long. But as well with participation certificates, we've got to first of all just build a bit of an Excel spread, list everyone that we need to send things to, and then just systematically go from there. So it might take a few days, but we will get them out. So if you don't hear from us, it's just that some of us are still in assessments, things like that. So we will get them out and we'll respond to all of you. We just need to firstly send messages to all the judges thanking them, so they'll come back next year. And then we'll get to the scores and the participation certificates.
Thank you for letting us know.
Read in the chat. That's all right. But yeah, any questions at all, anything that comes to mind, just email us. We'll still be on the email thread for at least a few weeks until they kick us out, I think, and get the new conveners in.
That's great. We'll stay in touch.
Yeah, definitely. Okay, I don't know. I'm wondering if no one has anything else they'd like to say. I know that it's getting late. I can see that you girls are not at home. You must be wanting to get home. So yeah, feel free to say anything else, and otherwise, thank you again. It's been a ride.
Thank you so much.
Thank you. Yeah. So yeah, you're like allowed to leave now. So yeah, you can enjoy your Wednesday evening. Yeah.
Congratulations to you.
Thank you, and congrats to everyone.
Bye.
Okay, bye.
So I'll stop recording and I will put the video up on my computer. Yeah.
Oh, amazing. Thank you.
Yeah. It's been a while since I've seen any of your faces, actually. It's so nice to see you all, not through our group chat.